Good morning. Happy Valentine's to everybody. I haven't seen too many little things of chocolate up my way, so I don't know what that means. Or maybe I do know what that means. Love is fleeting in this job. Y'all bow with me. Gracious Heavenly Father, thank you. Thank you for all the wonderful blessings. Thank you for what you do for us individually and corporately. Let us keep in mind what we're here for. We're here to help the state of Georgia and the citizens therein. Let us do things that will be pleasing to you and beneficial to our fellow man. Lead, guide, and direct us. In Jesus' name, amen. Again, good morning. Who sits right there? I saw it. Okay. Mr. Kidd. Didn't mean to wake you up over there. He's on which one? Wait just a second. Okay, we got you.
Thank you, Mr. Chairman. My day wasn't complete yesterday, Mr. Chairman, because I missed being here with you for another committee. But I hope I don't have to visit with you again tomorrow. But House Bill 68 is what we used to call a rabbit bill. It came out of Health and Human Services, and you know anything coming out of there has been massaged and looked at very closely. All it does is let the Board of Medical Examiners establish continued education hours for the people they license up to 40 hours biannually. That's all it does.
Questions? They've got to get 40 now. Is that what the deal is? And then this gives the board the right to reduce that, just not put it over 40.
That's correct. There are other people other than MDs who are licensed by that board.
Okay. You're not going to make it one or anything like that, are you? Yes, ma'am.
Thank you, Mr. Chairman. What happened is for their national recognition, they require 30 hours. And the board would just like to come in and make it the same with that national test and standard organization.
Okay. Thank you. Well, Mackie, you made it. Come on down. Y'all, you have to get on to him. Want to put a fellow's bill on the floor and he won't even show up. I don't understand that.
Thank you, Mr. Chairman. Happy to be here with you on this Valentine's Day. I'm here to ask for House Bill 160, which prohibits the... Let me say this, first of all. It's a bill that was around last term that made it all the way to a conference committee between the House and the Senate and just never got passed prior to the 40th day of the second session, and it passed the House overwhelmingly before. It prohibits the recording of a fee that runs with the land, a monetary fee, where any subsequent transferee of the land would be required to pay a fee to the person who recorded the instrument in the first place. There are exceptions in the bill for homeowners associations, property owners associations, condo associations, and things of that nature. The bill also contains a couple of minor tweaks that were brought up by attorneys who have had to implement the foreclosure registry bill that we passed last year. I would ask for the committee's favorable consideration of House Bill 160.
Mr. Earhart.
Thank you. Thank you, Mr. Chairman. Thank you. Can you hear that? Thank you, Mr. Chairman. Representative Jacobs, I like the underlying premise of the legislation. Give me a reason why we would want to exempt property or condo associations. These are not actors that generally need exemptions from good policy. They need more policy.
Right. Well, I understand. I understand your perspective, Chairman Earhart. But the fact of the matter is that those associations generally do record instruments that require the payment of a fee.
They're all about fees.
Pardon?
They're all about fees.
I understand that. I understand that, Chairman Earhart. Obviously this bill, having been through the process previously and come through judiciary, was the subject matter of some compromise. The language that you have there that is the exception was the final version of the bill that was pending in the General Assembly last term. I do think the policy in the bill is a valid one. In fact, more than 40 states have adopted exactly this sort of policy, and we've started to see these fees by non-homeowners associations and the like pop up in Georgia. So it is something that is necessary. I understand where you're coming from, but the language with the exceptions was something that was worked out over a long period of time with homeowners associations, condo associations, and their representatives here at the Capitol.
Mr. Earhart.
Continue to have a difference of opinion. I agree with the underlying policy, but I don't see the exceptions being good policy.
Mr. Hamilton. Never mind. All right, thank you.
Thank you, Mr. Chairman.
Mr. Battles.
Thank you, Mr. Chairman, committee. I bring to you House Bill 35, and we're working actually off of a substitute which was LC 35-2890S. This is to designate, by the approval of schools, boards of education, to designate a security person within their school system to go through a set of training and evaluation and ultimately to serve as that resource person for their schools. And I'll be happy to answer any questions that committee might have.
Ms. Hughley.
Thank you, Mr. Chairman. To Mr. Battles, how did y'all work out the liability associated with having a school personnel who is not a law enforcement officer be responsible for firearms?
Well, we actually worked out two areas of liability. One, for those schools that would not want to opt into this. This is a voluntary. This is not a mandate. And we did not want to put them in harm's way. So if there an incident happened in a school, then they would not be liable, and we covered this in the legislation. Secondly, most school systems have either a campus police with a very small force, and they would have liability coverage for them. It's leaving this up to the local boards of education on how that they cover those individuals who would be designated in those schools under the umbrella of their liability policy. But it would be up, we're putting all of the responsibility onto the school boards to make sure all of the things that we have covered in this piece of legislation occur before they can certify that person to be that resource officer. And so that liability issue is the same liability issue that they would have with anyone who is serving in a role of security for the school system. That may not have answered your question, and I don't think it did. What else?
Well, excuse me, I guess it's the nature of being an insurance agent.
Yes.
Liability is something that automatically comes to mind. But as a parent, particularly for elementary grades, it appears to be problematic because the resource officers are not normally at the elementary level.
That's right.
And if school administrators or anybody is going to have weapons at that level, I think most parents would be concerned.
Well, I think that there is a concern, certainly, and this legislation comes out of a concern. The concern of the most, probably the most porous and the most vulnerable of our school systems are our primary and elementary schools. And right now, they do not have a person there that could intervene in the case of a school invasion. This is only giving the boards of education the opportunity to opt into this program, going through a very strenuous training program, evaluation, not only evaluation in their proficiency of being able to use a weapon, but also in law, and also emotional and psychological backgrounds checks on them. So in certifying them, they would have to do all the certification that would satisfy their insurance company so that they would be included in that umbrella of their security for their school system. And if they fail to do that, then I can't imagine any school system would take the liability.
Mr. Hamilton.
Thank you, Mr. Chairman. You said that this allows for, I may have misunderstood you, one person, but really it's not restricted to that.
It is not.
It's up to that.
It is not. One or more.
And then the second question is, and I think this was a change y'all made in committee, it does not specify any position. So virtually any school employee could be the person that does this, correct?
This is true, and the reason for that is that there may be some who were in the system. Someone even pointed out you could have someone as a janitor that had prior military experience or prior police experience that might qualify and even be a better person to serve. But the key to this whole thing is that the training, either they've had the training, they've been certified, or they're going to be certified.
I'm fine with that. I just want to clarify. Thank you. And then one final question
Yes,
is
sir.
it talks about school functions.
Yes.
Would a football game be considered
That's
a school
function. As long as it's
Would a
saying that
state
safety
playoff
first.
in the Superdome be a school function?
That would be excluded because we're talking about the local school system.
Okay.
That would not allow them to go to another school somewhere because there may be restrictions there.
Mr. Setzler.
Hey, Mr. Chairman, to the author, we had some conversations earlier in the week about the training requirement. Could you highlight for me what's required? My concern is there are individuals who are very well trained and very competent with firearms who are not former military, former law enforcement. And I have some concerns about having statutory training requirements in our law in any way. We had talked about the school board having sole discretion to do that. It appears on line 27 through 34 that they don't have that discretion. Could you highlight how that works in the bill?
Well, actually, they do have the discretion in that there is, if you'll notice up in B, and then it says policy which would provide for, and then it gives the next 4 items. It says sufficient training of approved personnel prior to being authorized. Again, this is a determination by that school board if there has been sufficient training. We went even further by being a little specific about that, and that is the minimum including training on judgment, pistol shooting, marksmanship, and review of current laws relating to use of force. So we did get specific on some areas. We did want to take in consideration that there are some who have already had some law enforcement training, and if they've been certified, we use them. But again, Chairman, we're going back to the issue that we're giving the discretion to that local school board. They're taking the full responsibility of liability. And I would imagine that they would take that very seriously.
And I just say that because the language on line 28, their training shall at a minimum include, that's very prescriptive.
Right.
I know in line 63 through 67 it says, you know, a school board can't be held accountable civilly or otherwise for adopting or not adopting a policy, but we're very prescriptive on line 28. And I was of the understanding this was not going to be prescriptive, but elective for school boards with respect to training.
The G portion of that bill was put in there for the fact that if a system decided that they would not participate and there was an occurrence of an invasion into the school, that they would not be held liable because they had not necessarily opted out. They just decided that they would not participate. Again, this is by choice, not by we're not legislating them to the point where they have to do this. So this is just relieving them of the liability if they decide that they are not going to participate. We're not constricting them in any way. We're giving local control. That was out of the committee, that was what was generally discussed, was local control. And
that's Mr. Williams.
Mr. Chairman, very quickly.
Yes, sir.
I admittedly have not read your bill. Are there any provisions for who pays for the training and the employment?
Yes, sir. In this, there is a provision that says that the responsibility either or would include the boards of education, would pay for the training, and there could be other ways that those funds could be raised. They could even ask for grants. There could be those concerned citizens within the community that could donate money to this, and I would imagine some would do that. But someone will have to pay for the training, and I guess the first line would be on that local school board to take that responsibility.
Okay. Any other questions? Thank you.
Thank you very much.
Mr. Rogers.
Thank you, Mr. Chairman, members of the committee. Happy Valentine's Day. I bring to you today for your consideration House Bill 255, which is a departmental bill related to the Uniform Carrier Regulation Act. Under federal guidelines, there are 3 requirements of the UCR, and right now the Department of Public Safety is carrying out 2 of those requirements, and what they would like to do is to take on the 3rd requirement, which is the administration of the UCR fee, currently held by the Department of Revenue.
Any questions? Yes, sir.
When this bill was debated in committee, did the Department of Revenue testify?
The Department of Revenue did show up. We had a meeting in Public Safety and Homeland Security. They did show up. It's my understanding that both the commissioners are talking right now.
When you say they've talked, does that mean they've agreed that they all think this is a good idea, or is this a kind of a scope battle?
I don't think you will ever get someone to agree it's a good idea if maybe revenue goes away from them. However, they are continuing to talk at this point, and I believe that it will be worked out fairly soon.
Will you let us know when that happens?
Yes, sir, most definitely. We've had that conversation, yes, sir.
Any other questions? Thank you. Mr. Watson.
Thank you, Chairman, Committee. Happy Valentine's Day to everyone. I'm here to ask for House Bill 208. It is modeled after the legislation about 3 years ago relating to hospitals, requiring them to give vaccinations to its employees. And actually, the nursing homes almost all do this and are asking for this legislation to finish this up. Basically requires them to give vaccinations to their employees free of charge, and if they decline it, obviously no one's going to be forced to have vaccinations. Then it is recorded, and it would be part of that record. Be happy to entertain any questions.
Mr. Lindsay.
Thank you, Representative. I like the general premise of the bill. but I must admit I'm a bit mystified by sections B and C at lines 24, beginning at lines 24 of the bill.
Right.
B makes perfect sense because basically, I'll just sort of summarize that. B simply says that if a healthcare provider complies with the law, that there's no liability. Well, that makes perfect sense. What doesn't make sense to me right now, perhaps you can help me with, is C, where it says the failure on the part of a nursing home to comply with the provisions of this code section shall not subject such nursing home to any civil or criminal liability.
Right.
In other words, we are telling them if you follow the law, there's no liability, and then we're saying, well, if you ignore the law and you don't comply with the terms of the law, there's no liability. That doesn't make sense to me.
I understand your concern, and that basically came from a previous law. The Section B is exactly verbatim from the hospital vaccination bill before.
And we should have that in
right,
there.
And I'm in full agreement. And there was debate in committee on that, and we elected to keep it in. But I will say I have discussed this with the nursing home industry. If that's a block on the bill, then they are willing to take that out. That came from a bill last year relating to child care centers being required to give a piece of paper for recommendation relating to flu vaccination. And but that's
I don't want to belabor that point here. Perhaps you and I can sort of chat together afterwards and talk about that. That's my only concern about you.
Right, and that's not from the nursing home industry standpoint. Remember, they asked for this legislation. That is not a sticking point for them.
Okay, thank you. We can talk about that more later.
Ms. Cooper.
Mr. Chairman, Representative Lindsay, if you'll go back to the EpiPen bill and some of our members, when we said we gave them immunity if they gave it, and they were very concerned that some people would want to opt out and not give it, and they should get immunity too. And it sort of started back then, and that's how the nursing home industry feels. Well, what if I've got one, nursing home who doesn't want to do this? And that is why you see it in the law. And they don't want to do it unless they have that. Just the explanation.
I just think it sounds like ignore the law.
Okay, thank you. I'll be glad to take advice on that if something like that comes through again and ask you how to word it. Thank you, sir.
Mr. Weldon.
Chairman, Representative, in line 26, this bill would give nursing homes immunity from civil or criminal liability or for discipline for unprofessional conduct if they comply with, if they act in good faith and they act in accordance with generally accepted healthcare standards applicable to such nursing home or healthcare facility, right?
Yes.
And then, if they act in accordance with what they're supposed to do anyway, they wouldn't be liable for it, would they?
Well, as you know, and I know, in a court of law, many times that's not necessarily what is actually comes to fruition, but that is a provision that is that does give them immunity if they act in, as you said, generally accepted health care standards. Given the flu shot, the liability related to the flu shot, and that goes along with that. So that's the same provision that was in there for the hospital law that was passed 3 years ago.
So what this does is this gives them immunity from anything. Somebody goes in there and they give my 95-year-old grandmother.
Let me.
Hold on. Let me
okay,
just
excuse.
pose this
Go ahead.
question to you. They give my 95-year-old grandmother, who there's a standard that is different from generally accepted administration of that vaccination, and it's different from what it would be to give me or to give you that vaccination. This gives them immunity from liability for improperly giving my 95-year-old grandmother that immunization.
That's not what this bill does. Can I elaborate on that? This bill is for employees and not for the patients. These are free vaccines that they are giving to their employees, as a service to their employees, they're giving it free. Now, admittedly, if employees, it costs them money on the upfront, but if employees get the vaccination, they're going to have less illnesses and less absences. So it will save them money in the long run. This does not apply to your 95-year-old grandmother who's in the nursing home. And I concur with Representative Lindsay. I think this is a needed protection for them, offering free vaccines. Now, Section C, I think there's certainly discussion on. And I've discussed that with the nursing homes specifically, including yesterday, and they're okay with that.
Well, but don't you agree that there could be differing standards of care that would be required to be given to employees depending on their personal health situation? And accordingly, this would just shield the nursing homes from liability if it's administered improperly.
You're correct. It is a flu vaccine. That there are certain precautions that probably most of this room knows that you shouldn't take it if you have allergies to eggs or other issues relating to that. But there are very few contraindications. Most of the time, these flu vaccines, like the public health department in Chatham County, people roll up, put their sleeve up, and they get stuck after signing their informed consent. Same thing in Representative Stevens' pharmacy, same thing in my office.
If I could follow up.
No. Done. Madam Pro Tem.
I had a question, Representative. Do the nursing homes support having to absorb the cost, and there is a cost for the flu shots, as opposed to offering it and allowing the employees to...
That was actually my first question to the nursing home. Remember, the nursing homes brought this to me, and they are willing, and most of them do this now, give vaccinations for free to their employees, the ones that want it. And 95% of everybody wants to have the flu vaccine, and they document the ones that don't. They know that it does cost them money up front, but it actually, if they get the flu vaccine, it's going to protect them from the flu in most situations, and it's going to save them money related to absenteeism.
Thank you.
Thank you.
Thank you, Chairman.
Mr. Harrell.
Thank you, Mr. Chairman. I bring an amendment to House Bill 124. Under the kindness and generosity of the chairman of this committee, you placed 124 on the floor yesterday, and I made a proofreading error, and we failed to underline 11 words that should have been underlined. So there's an amendment that strikes line 58 and 59 and inserting in its place the 11 words that should have been underlined in the original bill.
Any questions? 19. Mr. Parrish.
Thank you, Mr. Chairman. Representative Harrell, let me ask you a question. I'm fine with your amendment, Chair, but on Section 3, it's my understanding that this is now in rules and regulations.
Yes, sir, of the Department of Revenue.
Right. Why are we putting this into law?
Two reasons. Primarily, there was a recent court case in Kentucky where in a similar situation, the definition was in rules and regs and not in code, and as a result, the locations where distilled spirits were able to be sold was expanded, perhaps beyond the intent of the state and the department, because it didn't have the force of law. So that is a primary reason of putting this in the code, and the Department of Revenue is supportive of that.
Could I ask another question, Mr. Chairman?
Yes, sir.
If you look down on line 89 down there, talks about selling packaged ice in packages of 5 pounds or greater. If I had a store, why couldn't I sell a 2-pound bag of ice if I wanted to? But right. According to this, if I did that, what would I be guilty of?
Right. The regulation of sale of distilled spirits, as you understand, is quite well guarded in the state, as I think it ought to be. So there's a very prescriptive list of products, and the department continues to have some flexibility, I believe even on that same line, it reads on line 90, that is in compliance with the laws of the state, rules and regs of the Department of Agriculture. So that particular product that you mentioned is regulated by the Department of Agriculture. So should availability of other items within that section be made available, then I think the department there would have the ability to promulgate some modification.
Well, if you look down on line 92, I could sell paper, styrofoam, or plastic cups, but if I sold a glass cup, would I be guilty of a misdemeanor?
Right. And again, this is in current department rules and regulations, but I believe if you look on 101, that takes care of the glass, plastic, metal. Again, the idea is that, quite frankly, it's been the policy of the state to not encourage those that ought not to be in a liquor store to enter. So I think part of the thinking in both the department and the industry to limit to a degree the products that are sold inside of a retail package store would be items that tend to be either strictly related to the sale of alcohol or age appropriate. And that's where this list was originally developed from. And again, it is in DOR regulations today.
Any other questions? Okay, thank you. Mr. Earhart.
Yes, sir, Mr. Chairman. I'd like to request House Bill 235. It's a bill that will expand the access to quality optometric and eye care for the citizens of the state of Georgia.
Any questions? Yes, we do. Ms. Jones.
Thank you, Mr. Chairman. Representative Earhart, ophthalmologists who are trained in pharmacology rarely prescribe oral steroids, in particular without consultation with the primary physician. What specific procedures or conditions would require optometrists to have access to prescribe oral steroids?
Not being an optometrist, I wouldn't know the specifics of that. 32 states in this nation, and all military health care, all veterans health care, all health care provided by the federal government allow optometrists who are also trained in pharmacology in the exact same way as the physician community of the ophthalmologist have that capacity. So it is the best practice in most of the states in this country, and the optometrists in Georgia feel like that it would be in the best interest of the citizens of the state of Georgia to have that same capacity. And I would also state that there has never, they have also been prescribing anything and up to oral narcotics like hydrocodone since 1972, and there has never been an issue, never been a court case with them on those prescriptive authorities. So I think they have a pretty good track record.
I'd like to have a little more information on it because it is a relatively significant expansion to go to oral steroids, and I'm just trying to understand what the specific procedures or conditions would require it. I'm not opposed to it. I just want to be more educated on this. Thank you.
Mr. Golett. You're mashed.
Sorry, Mr. Chairman, I didn't hear my name. I'd like to request House Bill 246. This is a administrative housekeeping bill requested by the World Congress Center Authority, came through insurance this week. What they'd like to do is to be able to go on the open market to shop for their flexible benefit plan. A year or two back, they opted out of the state health benefit plan. They thought at the time they could go ahead and go on the open market as well for the state for their flexible benefit plan, but DOAS informed them they'd have to go ahead and get that done legislatively, and that's what this is meant to do. The reason for that, their overall reason for doing that, is to go ahead and have it as attractive a benefit package as they can for prospective employees and executives over at the authority. And of course, we're all aware of the economic development driver that the authority has in the downtown campus, and the bill has the approval of the administration as well.
Mr. Weldon. Wait a sec. Are you
No.
questioning?
No, Your Honor.
Are there any questions of Mr. Gold? Okay, now Mr. Weldon.
Thank you, Mr. Chairman. I would like to respectfully request for this committee to consider House Bill 178 and place it on the legislative counter. This is the Georgia Pain Management Clinic Act that the House and the Senate both passed out last year, and we just bring it back this year so we can possibly get it to the governor. And also I'd like for consideration of House Bill 182, which is on the yellow sheet about halfway down. This is the Juvenile Court Administration hearing on the order of an associate juvenile court judge. This just takes away the second bite at the apple. This associate juvenile court judges did not have to be lawyers. Then we changed the requirements to require that associate juvenile court judges have the same qualifications as the elected or appointed juvenile court judge, and this just does away with a second bite at the apple, and it's cost effective. Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. Since this committee controls both structured bills and modified structured bills in terms of having access on the floor, I would ask the chairman to consider if HB 35 is moved to the floor for consideration tomorrow or the next legislative day, that be modified structure so that I could offer a friendly amendment for the gentleman to accomplish what I believe is his intent in the bill.
Noted. Any questions of Mr. Weldon about his two bills? No questions. Okay. This is the calendar for Tuesday. Under modified open, HB 68. Any opposition? It's on. Under modified structure, HB 124. Any opposition?
Mr. Chairman, isn't there an amendment we need to vote?
Yes, there is, and I forgot about it. Let's start that again. You've got a HB 124, and you've got the amendment AM 360407 on your desk, or should have. We've determined that we can do that in rules. It's a minor thing to underline. So I would accept a motion to have a motion and a second. Any discussion on that? Any opposed? Yes, sir.
We need to specify, is that as a rule substitute or as an amendment to go to the floor?
So it's modified structure amendment that will go on the floor. All right. Now we'll go back. We're going to put HB 124 as amended in rules under modified as not amended.
We need to vote on the amendment.
I'm sorry. Everybody in favor of the amendment say aye. Aye. Any opposed? All right. So it's just it's not going to be a rule substitute. It's going to be an amendment on the floor for 124. Does everybody agree with that? Okay, it's on there. HB 246 under modified structure. Any opposed? HB 235 under modified structure. All those in favor signify by aye. Aye. Opposed? It is the right of each member of this committee to ask for a delay of 1 day. So we'll take it off. I'm going to let it go. Under modified open, HB 182, the yellow sheet, not the blue. Do I hear a motion? Any opposed? It's on. Okay, that's the calendar. One other thing, we're not through. We're not through. I want you to remember that you have a meeting at 11:30 or adjournment, whichever's latest, and back in this room, and it will be for 142 and 143.